Okay, so yesterday you got there in the afternoon to Rexburg. Okay, so yesterday you got there in the afternoon to Rexburg, and you, as that search was going on, there were roads blocked off for I think you said a mile or two. Tell you why it was blocked off in such a wide area.
They didn't go into specifics. That's one of those things that police yesterday weren't taking a lot of questions. They were
Hold on, guys.
with a lot of things, but again, a couple of miles in each direction from this house. And keep in mind, we are here in Fremont County, very rural roads, a lot of houses out there, but very spread out. And so, based on where we were, we drove all the way around trying to find a road that was.
Okay, I'm sorry, Misty. I'm gonna have to cut you off right there because the hearing is actually starting now. I know you want to listen in as well, so let's also listen in Chad Daybell's initial course up here.
Sorry about that.
Mute my mic and turn off my camera, but I'm not leaving the meeting. I'm right here.
Judge, we're going to do the same as well.
All right, we're only going to be about a minute and a half, and then I'll start.
Hey guys, can y'all hear the audio okay?
As you heard there, Judge Farron Edens was giving the prosecution and
All right,
the
we're going to call up the case.
about a minute and a half, and that went pretty quickly. Let's listen in.
Okay.
One moment.
More evidence of the times that we are living in right now. So many things happening by Zoom and teleconferencing. And as you see, the judge and a clerk are the only ones in the Fremont County courtroom right now. The prosecutor, Rob Wood, up there in the upper right-hand corner, is remotely patching into this hearing, as well as Chad Daybell there in the left in the prison outfit, or the jail outfit, I should say, and his attorney, John Pryor, waiting for this to get started as the judge sets things in place. No
We're going to go on the
reporters, no
record. Good
public
morning
allowed
here
in the courtroom either.
in Fremont County, Idaho. This is the case of CR 2220-755, State of Idaho versus Chad Guy Daybell. This matter is being held at the Fremont County courtroom via Zoom remotely.
I'm going to make it a little louder
Mr.
for you
Daybell,
guys.
the defendant, appears with his counsel, Mr. Pryor, at the jail here in Fremont County. Mr. Wood appears remotely from his office. There is the clerk here, there's a court reporter, and there is some IT support that is also on the line. This is the date and time set for an initial appearance. The reason we're holding this hearing remotely via Zoom is due to a order that's been issued by the Supreme Court. In that order, it designates that whenever plausible, hearings are to be held remotely in order to effectuate safety of society and effectuate safety of all employees in the courtroom. In future proceedings, it will be an issue that's addressed case by case and hearing by hearing. That order is dated April 22nd, 2020, and has been issued by the Idaho Supreme Court. Mr. Daybell, do you read, speak, and understand the English language?
Yes.
Mr. Daybell, can you hear me okay today?
Yes.
Mr. Daybell, it appears that you have hired private counsel, Mr. John Pryor, is that correct?
Yes.
and you'd like to retain him. Mr. Pryor, has there been a formal notice of appearance that has been entered?
Judge, I will get that filed within a short period of time.
All right, but Mr. Daybell, Mr. Pryor is your attorney for this hearing, is that correct?
Yes.
Mr. Daybell, have you seen a notification of rights form that was provided to your counsel prior to the hearing here today?
Yes.
Do you understand all of your legal rights?
Yes.
Mr. Daybell, in addition to the rights that were contained in that notification of rights form that was given to you, I'm going to advise you of additional rights under Idaho Criminal Rule 5. Number one, you have the right to be at the initial appearance or appear via Zoom remotely like you are today. You don't need to make any statements today. You have the right to know what charges are being brought against you. You have the right to bail. You have the right to counsel. And you have all of the other rights that have been presented to you in that notification of rights. Do you have any questions about your rights, Mr. Daybell?
You'll get it back, True Helper.
I didn't hear your answer.
Doing a test.
No. He does not.
You understand your legal rights, is that correct?
I do.
All right. Mr. Daybell, did you receive a copy of the warrant of arrest as well as the criminal complaint that has been filed here in Fremont County in this case?
Yes.
Mr. Daybell, have you had a chance to review that criminal complaint as well as the arrest warrant with your counsel?
Yes.
Mr. Pryor, I can read the criminal complaint in its entirety, or I can summarize it for you.
Judge, we'll waive actually formal reading of the criminal complaint at this time, and I've discussed that matter with Mr. Daybell, and we're ready to proceed forward without either a summary or a formal reading at this point.
All right. The court is going to summarize briefly what the charges are, so that's on the record, and then we'll address the other issues we need to address. Let me get one more thing out of the way, Mr. Pryor. Ultimately, the Supreme Court order has ordered these hearings be held remotely, but it's my understanding your client is willing to waive his right to be here in court in person. Is that correct?
It is, Your Honor. Thank you.
Okay. Mr. Daybell, is that also correct?
Yes.
With regards to the criminal complaint, it was filed dated June 10th, 2020. There are 2 counts in the criminal complaint. The first count is destruction, alteration, or concealment of evidence, a felony, a violation of Idaho Code 182603. The maximum punishment for that charge is up to 5 years in the state penitentiary and or up to a $10,000 fine. The allegation is that the defendant, Chad Guy Daybell, on or between the 22nd day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully conceal and or aid and abet another to willfully conceal human remains, knowing that said human remains were about to be produced, used and or discovered as evidence in a felony proceeding, inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used and or discovered. Count 2 is also the same charge, destruction, alteration, or concealment of evidence, a felony. It's punishable by up to 5 years in the state penitentiary and or up to a $10,000 fine. It alleges that the defendant, Chad Guy Daybell, on or between the 8th day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully destroy, alter, and or conceal human remains and or did aid and abet another to willfully destroy, alter, and or conceal human remains, knowing that said human remains were about to be produced, used, and or discovered as evidence in a felony proceeding. Inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used, and or discovered. Mr. Daybell, do you understand the allegations on both counts that have been brought against you?
I do.
Mr. Daybell, do you also understand the maximum penalties on each of those counts?
Yes.
Mr. Daybell, do you understand that those maximum penalties could run consecutively, one after the other, or they could run concurrently? Do you understand that?
Yes.
All right. We've gone through the criminal complaint. We've gone through each count. I've advised the defendant of his right. We've gone through that form. Let's discuss the next hearing that's going to be set. Mr. Pryor and Mr. Wood, that next hearing would be a preliminary hearing or a probable cause hearing. The defendant has a right to have that within 14 days if he's incarcerated. It's my understanding that based upon previous conversations that there'll be a waiver of that speedy preliminary hearing. Is that correct, Mr. Pryor?
It is, Your Honor. I've had that discussion with Mr. Daybell. In addition, I've had that discussion with Fremont County prosecuting attorney, and at this point, we'll waive the time.
Mr. Wood, is that correct as far as the stipulation?
Yes, the state's fine with that, Your Honor.
Mr. Pryor, the court's going to grant that waiver and acknowledge that it's knowingly and voluntarily made, but I will need a written waiver of speedy preliminary hearing so that can be in the file for the record. Do you understand?
Yes, Your Honor. I'll do that. Thank you.
All right. With regards to a preliminary hearing, let's first talk about the logistics of that. Mr. Wood, how long do you foresee it taking to accomplish a preliminary hearing in the future?
No longer than a day.
Okay. 1 day. Mr. Pryor, do you concur with that?
Judge, I'm at a little bit of a disadvantage, but for practical purposes, I think a day would be appropriate.
All right, we'll set this for 1 day. Mr. Wood and Mr. Pryor, do you have a timeline that you'd like to look at as far as scheduling that today?
Judge, my preference would be within 4 to 6 weeks.
Mr. Wood?
That's fine. We do have a preliminary hearing on July 9th and 10th in the Lori Vallow case. And so if we are going to push it out that far, I'd ask that this prelim be at least the week of the July 16th.
Unfortunately, I'm going to be out of town the week of July 16th, and I won't be back for some time. So if we need to have it in July, it probably needs to be towards the beginning of July or into June. Otherwise, it's going to have to be the last week of July. Mr. Pryor, does that work with your schedule?
Judge, the latter part of June and the first week of July, the 1st and the 2nd of July would be ideal for me if that's available to the court and to Mr. Wood.
We can
Mr.
make
Wood?
that work.
All right, let's look at dates then. I'm looking at the calendar. The end of June, it looks like those Monday is the 29th, and then Tuesday is the 30th, and then Wednesday is July 1st, Thursday, July 2nd. Which of those days did both of you prefer?
I think the 2nd would be best for the state.
Mr. Pryor, does that work for you?
Judge, I believe the 2nd falls on a Friday, if I'm not mistaken. So I would like to see if we could do the 1st, and if necessary, we can have the 2nd available in the event this thing runs a little longer, Your Honor.
Okay, so the 2nd is a Thursday, Mr. Pryor, but I appreciate that you would like to have extra time if it does go over. So if we set it for the 1st, Mr. Wood, can we do that? And then if it spills over into the 2nd, we'll make sure that date's available.
That'd be fine.
Okay. We'll set that then July 1st and July 2nd for the preliminary hearing or the probable cause hearing. Lastly, the court has issued the arrest warrant. The court designated that it would address bond and or bail at the hearing set today. And so I'd like to hear argument from both parties regarding bail. So why don't I hear from the state first, and then I'll hear from the defense.
Thank you, Your Honor. The state is requesting the bail be set at $1 million. While we recognize that felony concealing of evidence only has a maximum sentence of 5 years per charge, I think the background and context of this case necessitates a higher bail. One of the primary reasons we are asking that bail be set in that amount is that the evidence that has been concealed in this case, it's not simply a document, drugs, a gun. These are human remains. And we can, although those remains have not yet been positively identified, we are aware that those remains are the remains of children, which we believe is an aggravating factor. We have asked that the probable cause affidavit be sealed, but I would ask the court to take note of paragraphs 39 and 40 and the manner of the concealment of one of those bodies, which the state finds to be particularly egregious, both an aggravating factor and bears on character as Rule 40 as Rule 46 allows us to look at. Your Honor, we understand that the possible sentence on this case is not that long, but knowing what the subject matter is, we find it extremely serious. And we would also note that because of what has been found on Mr. Daybell's property, should he bail out, he has strong incentive to flee. Clearly, this is the beginning now of an investigation into the deaths of children who are found on his property, and so that provides a strong incentive to flee, and we would ask that the bail reflect that. Whatever the court sets as bail, we would ask that the conditions be set that should he bond out, that he be required to wear an ankle monitor, and that his movement be restricted to Madison and Fremont counties.
Thank you, Mr. Wood. Mr. Pryor, I'll hear from you next.
And Judge, just for purposes of the record, my understanding is the court's allowing us to address this issue of bond, but that in no way limits us in the future to file a further motion for bond if that's necessary. I believe that's the court's understanding, Mr. Wood's understanding as well, is it not, Judge?
Let me make that clear for the record. Because of the nature of timing and such, generally speaking, the court sets a bail based upon a probable cause affidavit, and then if a motion needs to be filed after, it can be filed. I did not set a bail because, frankly, it was timing. And so, correct, Mr. Pryor, I'm going to give you complete ability to file a renewed motion or a first motion to deal with bail. I guess de novo is how you could look at that. And so I'm going to set bail today. When you file your motion, the court will definitely give you a hearing for that, and we'll take it and make a decision based upon that.
Thank you, Your Honor. But in regards to argument, Your Honor, I would point out that the charges are, as Mr. Wood pointed out, carry a maximum of 5 years. Mr. Daybell is not charged with anything more serious. And quite honestly, for the prosecuting attorney to assume that in the future he may or may not do that, and that we should increase the bail with the idea that in the future there may be something else coming down the pipe is just clearly contrary to what the purpose of bail is. Bail is to assure that Mr. Daybell shows up to court. Bail is to assure that he's not a flight risk, and there's nothing, in, as far as I'm concerned,
there were bodies found on his property.
He's going to flee the jurisdiction. I would refer the court to the affidavit on number 26, and it talks about the last time that they saw the kids. If Mr. Wood's intention is to pursue further charges, my belief is that he would have pursued those. And quite honestly, at this point, the court needs to take consideration of what the current charges are and whether or not Mr. Daybell will show up to court. Mr. Daybell has taken the initiative to hire private counsel. He has shown up to the proceeding today. Obviously, he's in custody. But Judge, when the police showed up at his house last night, Mr. Daybell didn't flee. Mr. Daybell didn't abscond. Mr. Daybell didn't run. Mr. Daybell's intention was, through his counsel, to turn himself into the court if that was something that was going to happen and address these issues. He has every intention of addressing these issues. He has significant family in the community. He has kids that live here. He owns property here. And quite honestly, I disagree with Mr. Wood. Mr. Daybell has every intention of staying in the community and every motivation to stay in the community and address these charges. So at this point, Judge, I would ask the court to put the bail at an amount that's appropriate for a 5-year felony sentence. I understand that there's been a significant amount of publicity with this, but publicity is not a reason to raise the bail to an extraordinary amount. And I would suggest that Mr. Wood's suggestion that a $1 million bail is okay, it's not okay, Judge. A $1 million bail is not okay for a 5-year felony sentence. And if in the future Mr. Wood decides to pursue other charges, I'm sure we'll address this again. But at this point, Your Honor, I think it's important for the court to set a bail at an appropriate amount based on the 2 felony 5-year sentences. I would ask the court for $50,000 on each count for a total of $100,000, Your Honor.
Thank you, Mr. Pryor. The court has listened carefully to the argument of both parties. The court has reviewed Idaho Criminal Rule 46, specifically the factors contained in Idaho Criminal Rule 46 under subsection C. There are 10 different factors that the court has looked at. The court has also looked carefully at Idaho Code 192904 and the factors that are designed therein. In looking at the factors in 192904, there are 4 specifically that the legislators have set forth. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court is cognizant that there is an absolute constitutional right to bail provided in both the Idaho Constitution and the U.S. Constitution. The court has taken all of those factors into account, and based upon those factors and the charge, the court is going to set bail in the amount of $1 million. The court notes that the charge is destruction, alteration, and concealment of evidence as pertained in the criminal complaint. I've taken all those factors into account. Specifically, the factor in Rule 46C, subsection 6, which designates I'm to take into account the nature of the current charge and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. The underlying charge here is destruction, alteration, and concealment of evidence, and the allegation is that the evidence was human remains of 2 different people. That's an aggravating factor, and the court has taken that into account. If bail is posted, Mr. Pryor, I'm also going to make conditions of bail. Those conditions will be as follows.
He would need $100,000 to bail out.
Number 1, I'm going to order that a waiver of extradition be provided to the Fremont County Office of the Sheriff. The prosecutor must approve the waiver of extradition by his signature on the waiver of extradition. A copy of that waiver must be filed with the court. Number 2, I'm going to order that the defendant shall reside within the boundaries of Bonneville, Jefferson, Madison, and Fremont counties in the state of Idaho. The defendant shall not leave these counties for any reason. Number 3, the defendant shall provide the court with his current address and shall not change his address without notifying the court. Number 4, the defendant shall keep in regular contact with his attorney. Number 5, the defendant shall appear for all court appearances. Number 6, the defendant shall obey all laws of the state of Idaho and the United States of America. Number 7, the defendant will sign up for pretrial services and check in with pretrial services here in Fremont County on a weekly basis, as directed. The defendant shall have absolutely no contact with the victims' families and or any of the state's witnesses in this case. Contact shall include, but be not limited to, verbal contact, written contact, visual contact, text messaging contact, email or internet contact, and or telephonic contact. Such contact shall also include contact through third parties. Number 9, the defendant must wear an ankle monitor 24 hours a day, 7 days a week. He must have the ankle monitor in place before he is released from the Fremont County Jail. Any violations of the geographical limitation imposed herein must be reported immediately to the Fremont County Sheriff's Office and the court. If the defendant is notified that under the order to wear the ankle monitor, intentionally leaving the area of restriction, except for the purpose of obtaining emergency medical care, may be prosecuted as a crime of escape and subject the defendant to penalties under Idaho Code. If the defendant fails to comply with all of these terms, the court may, pursuant to Idaho Criminal Rule 46I and Idaho Code Section 2919, revoke the defendant's release and eligibility for posting of bail. Mr. Daybell, Mr. Pryor, do both of you understand what bail has been set at, as well as any conditions that must be met in order for that bail to be set?
Yes, Your Honor. Yes.
Mr. Wood, any questions?
No, thank you, Your Honor.
All right, we'll be in recess for today, pending that preliminary hearing. There will be a few things that need to be worked out, and we're going to go off the record for now, and I'll see everybody back here at the beginning of July. Council will have to communicate regularly, both with the court and with each other, about how this hearing is going to be held, whether it's going to be held remotely or whether it's going to be held in person. Mr. Wood or Mr. Pryor, do either of you wish to address that issue today?
Not today, Judge.
No, and I can, Mr. Pryor and I can visit and talk about that and see if we can come to an arrangement before we address that issue with the court.
All right, I will just state for the record that the court will need to make findings if we're going to do it live in person, and we'll address that at a future hearing on whether or not that's going to take place. With that, we'll be in recess.
Yes, Pyramid.
Thanks, everybody, for appearing.
That's Fremont County Judge Farron Edens wrapping up today's initial court appearance for Chad Daybell, who is now officially charged with 2 counts of destruction, alteration, or concealment of evidence. 2 major things came out of this. First of all, the bail that you heard about there. The judge setting bail at $1 million with several conditions, including if Chad Daybell were able to bond out, that he would have to wear an ankle monitor 24/7, and he would not be able to leave 4 counties in eastern Idaho. The really, really big fact that just came out was the prosecutor, Rob Wood, saying and acknowledging that the remains found, 2 sets of human remains found on Chad Daybell's property yesterday by law enforcement searchers, were the remains of 2 children. Of course, this whole case revolves around 2 missing children. Still has to be confirmed that these are the remains, but J.J. Vallow, Tylee Ryan have been missing since September. The criminal complaint lays out very clearly the timeline for that disappearance. And so that is where the prosecutor is now focusing. His argument for the stiff bail, $1 million, was that the circumstances surrounding the case require it, saying that the mitigating or aggravating circumstances, the aggravating circumstances in this case being that these are the remains of 2 children and that they are human remains, and that the charges only carry a 5-year sentence, but the charge is for destroying evidence. And so because the evidence in this case is human remains, the prosecutor asked for $1 million bail. The judge agreed and set it at that. Our Misty Inglet is in Rexburg in Fremont County today. She has been covering this case and listening in on this hearing as well. Misty, to me, the thing that really hits home is that the remains, according to prosecutor Rob Wood, are those of 2 children. People have been asking for 8 months now, where are these kids? Can you hear me, Misty?
Yeah, absolutely, Doug. I mean, I think that's the thing that immediately jumped out. I know that's absolutely what jumped out at me. And again, from police this morning, official word is
Yes,
that is
FBI
still
were there.
pending on those autopsy, but that prosecutor in his argument with the bail that not only the seriousness of the case, we're dealing with 2 separate human remains, but that they believe those remains to be of children. And again, we mentioned earlier, you just mentioned as well, that the dates on those charges for Chad Daybell, one of them is September 8th, which is the last day that Tylee was seen. The other date's September 22nd, which is the day before JJ was reported last seen. And so it all kind of fits in together there. And again, just to kind of recap what we just heard in court there, it's 2 felony charges to conceal, alter, or destroy evidence. Both carry a maximum penalty of up to 5 years in the state penitentiary and or a $10,000 fine. Again, that's for each charge. Defense tried to argue that because it only carries a 5-year sentence, that bail should be set lower, something more reasonable. Defense requested it to be $50,000 per charge, so a total of $100,000 on bail. The judge ultimately sided with the prosecutor that because of the seriousness of the case, because we are dealing with 2 sets of human remains, that be set at $1 million. And that is, if you remember, that is also the same amount of bail that Lori Vallow is currently set at as well. So some similarities there. And again, this was all done via Zoom. This was all done remotely with the prosecution, Daybell and his attorney appearing remotely from Fremont County Jail. Now, they did not go through any of the evidence, the probable cause affidavit. None of that was mentioned today. That will be at Chad's next appearance, which will be his preliminary and or probable cause hearing. And they did set that for July 1st and 2nd, so coming up in a few weeks. That based on law, Chad has a right to have that hearing within 14 days of being arrested. But Chad and his attorney waived that right today. So again, that is set for July 1st and 2nd. And yeah, Judge, just going back to the point that not only the bail set at $1 million, Chad's still in custody right now, but that biggest thing was the human remains. And following off of that, because of the seriousness, I think you mentioned this as well, there are some conditions if he does post bail, which would include he would have to wear an ankle monitor, and he would be restricted to Bonneville, Jefferson, Madison, and Fremont counties, and would not be allowed to go outside of those counties. He would also have to maintain contact with the court, maintain contact with his attorneys, make sure he's showing up for those hearings. And so that's kind of the highlights from what we've got out of court today. So quite a bit to unpack for even a quick hearing. A lot of information out of that, Doug.
I believe the hearing was about 26 minutes in total this morning, a lot of it procedural. And speaking of procedure, the remains still have, their autopsies have to be performed. Positive identification has to be made, of course. We are hearing, though, that these are 2 children who are missing. Police didn't say much to you yesterday, Misty, about this, but is there any indication of how long it might take until that identification is able to be released, considering that the next court hearing will be in just 3.5 weeks or so?
Yeah, again, Doug, you mentioned it right there. We reported on it yesterday as well as a little bit earlier. Police pretty tight-lipped up to this point. They haven't released a lot of details, and they haven't been taking questions from the press. However, when they did make that announcement yesterday that they had found remains, they did mention that. They did say that they wanted to be forthcoming about what they had found, in part, to quell some of those social media rumors, some of that speculation that was out there. So they did want to be as upfront as possible. But again, they were very clear that they want to wait for that confirmation, that identification before they release more details. They didn't give any sort of a timeline or any, sort of a goal or an idea of when they would want those remains back or identified.
One final question, Misty, before we wrap it up and prepare for the news at noon. You were at the scene all day yesterday. Is there anything still going on Chad Daybell's property in terms of the search warrant or actual digging? Is it still sealed off?
So we were back out there around 7 o'clock last night, just before police called that additional press conference later. When we were out there, there was still tents set up. There was still crime scene tape all around his property. There was still a backhoe on site, and there were still law enforcement. There were still trailers for law enforcement there. We have not had a chance to go back out there this morning because, of course, we came straight here to the courthouse so that we could be prepared for that hearing for Chad's appearance. So we haven't been out there yet this morning, but as of around 7:15 last night, they were still on site. And they did say at that press conference that they were still searching the property and still continuing to look for any more evidence that they might find.
All right, Misty, I'll let you go now and prepare for the news at noon, which is coming up in just 18 minutes from now. Huge developments today in the case of the two missing children from Rexburg, Idaho, J.J. Vallow and Tylee Ryan. The judge has set bond for the husband of the children's mother at $1 million. For destroying or concealing evidence, 2 counts of that, felony counts, and also the prosecutor acknowledging that the remains found on Chad Daybell's property were those of children. No identity, of course, confirmed on those remains at this time. This case is full of twists and turns that we have extensive reporting on since late last year. You can text the word missing to 208-321-5614 for a link to all of our coverage. Again, that's missing, just the word missing. You don't need the quotes, to 208-321-5614. Text that and we'll send you a link within seconds to all of our coverage leading up to this. We're going to take a break here for about the next 17 minutes, get set for the news at noon, and we'll recap all of this for you.
Okay, well, he has a right to bond, right? That is his constitutional right. However, they set it so high that he will not be able to make it. Let's hope, right? That property, anybody in the chat, his children, unless he has a different property, his children were actually living at a property. Is that the same one? Because if you recall, his children were living at a property. The news tried to go to that property, and they shooed the news away. They would not speak to the media whatsoever. So I'm wondering if that is the same property. Okay. Thanks, Jen B, for confirming that. Interesting. So it makes you wonder how much his children know. His children are older. I'm not sure exactly the ages, but I think he has more than one child. It's almost like they were all staying there at the house. This is closure, but yet, you know, obviously they were able to tell that the remains were that of children. I'm thinking due to the size of the skeletal remains and possibly the hair, that's how they were able to confirm. The news did confirm via the mayor last night. Yeah, Kay, the grandma, did say, yeah, he has a 14-year-old. Okay. Now, is the preliminary hearing going to be on July 1st and 2nd? Do they need a 2-day to get a preliminary? I'll be watching on the 1st and the 2nd just to make sure that we get this. This hearing right here was supposed to be closed to the media. I'm surprised. That's why I was so late getting it. I was on the phone for a little bit, and then I did have a dentist appointment. I had that rescheduled because I was like, oh my gosh, they are going to do this live. So I was glad they were able to show it. Oh gosh. One other thing. What was I going to say? Okay, so she's in she's in jail. Obviously didn't make bond. He is now in jail. Um, this whole religious cult that they have, they think that the world's going to end next month. They seriously think that. I'll post the link here. Hold on just a second. Yeah, they think that the world is going to end next month. I don't know the actual day. I just heard July 2020. Let me put this in the chat here. There you go. July 6th. Funny. Yeah, let's have that preliminary hearing before the world ends, right? I think her bond was set at 1 million as well. It was reduced from 5 million to $1 million. So are they in the same jail right now, you guys? Or are they in different ones? Rexburg. They are actually members of the same church that Melanie, her niece, is a part of, which is Jesus Christ Latter-day Saints. LDS. Weird stuff. And I watched all those interviews with the niece, Melanie Boudreaux, which she's got a new name now. But I watched all those interviews, and I thought about going over and doing a live, and just, if you pay attention, like when her new husband talks, she's constantly like, if he says something that she doesn't approve, she'll rub his hand and he'll like change the subject. It's really interesting. But I think he knew more than she liked him divulging to the media. She did not like some of the things that he was saying. Yeah. Yeah. So, any questions in the chat? I've actually got to run to town. So, I don't want to make this too long. Thanks everybody for joining. Please share the link. Like or unlike, it's all the same via YouTube. So, but I do ask that you share the link. And yeah, I think he will sell her out as well. Because the way her brain thinks, and this is just my opinion, her smirks and her smiles in court, she thinks she's going to get off clear with this. Okay? Beings that it was his property before they were married. Technically, it's his property, right? So, who knows if she was even put on the deed yet? I mean, because they got married in Hawaii, and then they were arrested, and they were extradited from Hawaii to Idaho. You're welcome, True Helper. Hugs to you as well. Looks like, yeah, they're doing a 17-minute recess, the news is, and then they're going to probably just go over. They've got the article up now for what the live stream that they just had. So I'm going to go ahead and post that in the chat as well. You all can read that. Let me just go over this real quick and see what they say. So looks like they've already started the autopsy, which is good. Autopsy results are pending. They reinform us, Assistant Rexburg Police Chief Gary Hagan said the remains have not been identified. Of course, the mayor last night did kind of let it slip that they were the children. Okay? I guess there was enough evidence there to be able to tell, or the mayor would not have said that. If the autopsy comes back that they are in fact not these children, it makes you wonder what all they are really into. I mean, um, 2 bodies, come on, alright? Oh, who knows? Who knows if they're going to blame this on Alex? I wouldn't put it past them. Would not put it past them. They did confirm that the warrant was related to the disappearance for his property. The warrant right now is currently sealed, so I cannot pull that up. Okay, it says Lori Vallow, Daybell's wife and the mother of missing children, is charged with 2 felony counts of desertion and non-support of dependent children, as well as misdemeanors for resisting or obstructing officers, criminal solicitation to commit a crime, and contempt of court. She remains held in the Madison County Jail. Police have previously said that Vallow and Daybell have tried to mislead law enforcement about the children's whereabouts and have repeatedly refused to say where they are, if they are safe, or what happened to them. In addition to the missing children case, both Lori Vallow and Chad Daybell are also under investigation in connection to the October 19th death of Chad's late wife, Tammy Daybell. The woman's death was originally believed to be from natural causes, but later ruled suspicious, and they have exhumed her body. Shortly after she died, they married. And I don't know if you all are aware of this, but Charles Vallow actually had a larger life insurance policy on Lori. So it's almost like they were at a race. I guess she thought that her life was in jeopardy. So she wanted to beat him to it. Yeah. I'll get the numbers for you all later. But yeah, the life insurance policy that he had on her was larger than the one she had on him. I'm thinking close to $2 million. And the one that she had on him was around $1 million. Okay, so back in January, Charles Vallow warned police, saying that she had lost her mind, that Lori had threatened to murder him, and that she might be a danger to the children. He quotes as saying, "I don't know what she's going to do with them. Flee with them, hurt them." And they have him on body cam saying that shortly before he was murdered by Lori's brother, Alex. But as I showed in a previous live stream of the body cam footage of the day that Charles Vallow was murdered, the brother Alex Cox actually said initially that Tylee, the daughter, and Lori were in a scuffle. And then he changes it up and says that no, Charles and Lori were in a scuffle. So I thought to myself, well, if she can get in a scuffle with her own daughter, that says a whole lot right there. So, do we know what jail he's in? Let's see. Let's look at the mugshot again. Fremont County Sheriff. And she's in Madison County Jail. So they're not in the same jails. Okay, guys. I'm going to go ahead and cut this. Thanks for coming, you all. If you have any questions or anything, try to leave a comment in the comment section. I'll try to get to it. Pray for this family, you all. This is closure, but this is not how we wanted this to end whatsoever. I still had hope that they were going to be found. Alright? Much love to you all. God bless. And anything else breaks, I'll be live. So be watching for me. Much love.